Hello, my name is Joe Adelisi, and I'm an attorney, and what we are presenting here now is an educational seminar on estate planning and the use of living trusts in estate planning. So that's the topic for this seminar. Before we get started, I have to give you this disclaimer. What we're going to do is be presenting some ideas and strategies on estate planning and the use of living trusts, but none of this is meant to be specific legal advice. If you need to get specific legal advice, you need to talk to an attorney yourself personally. Our agenda for this seminar is going to be what makes up an estate, what is an estate, what are some of the common estate planning techniques, what is probate, how a trust avoids probate, and lastly, how you select an attorney to help you plan your estate. And when clients come in to talk to me, I ask them if they consider who they think are in the top 25% of income earners, because in estate planning, everything is driven by taxes. And when I ask people who they think is in the top 1%, a lot of times they'll say, oh, that's people that make, $1 million or more. And if I say, who do you think is in the top 5%? And they say, well, that's probably people that make about $500,000 or more. And if I ask them, well, who do you think is in the 10%? They'll say, well, maybe that's someone who's making $250,000 or more. And top 25%, they'll usually tell me that's probably people that are making over $100,000. And as you can see here, in fact, the income levels are quite lower. The top 1% actually make about $380,000. Top 5% are $159,000. The top 10% make $113,000. And if you make $67,000 or more, you're in the top 25%, believe it or not, of income earners in this country. And that's important because all of the estate planning techniques that you hear of and all the financial planning techniques that you hear of on the internet or people that are trying to sell books, the people that are trying to sell their books or sell their programs, the legal internet sites, you have to think from a marketing standpoint, who are they trying to target? Are they trying to really target the top 25% to sell the most books or the most plans that they can through the internet? A lot of that advice from a marketing standpoint is targeted to the larger audience, the 75%. And what you can see here is if you are in the top 25% of income earners, you're not in the bulk of what these pundits are trying to target. Your income really is not common, it's uncommon. And I know that's hard to believe when you think about it, that if you make $67,000 or more, that your income level is uncommon. But from a statistical standpoint, it really is. And I like people to understand that before we even get into the planning process. So keeping that in mind now, what is estate planning? Estate planning is the orderly transfer of your assets to the people that you want to have them, obviously at the least cost. You want it to happen as quickly as possible and, more importantly, without paying taxes. So what makes up an estate? An estate is all of your property. It's all of your stuff, your personal belongings, your home, real estate, cash, CDs, savings accounts, checking accounts, stocks, bonds, mutual funds, insurance, can be collectibles, art, if you have a gun collection or a coin collection. These are all things put together that makes up your estate. So I usually ask my clients, how long has it been since you took the time to seriously review your personal estate? Because most people spend probably 20 to 40 years building an estate or building a business only to have the government rip it apart overnight when it comes time to settle it. And in my opinion, if a business is worth building or if an estate is worth building, it's worth keeping as much as you can. So you want to protect yourself and, more importantly, protect your family. So I ask clients, doesn't it make sense to protect the estate that you've spent a lifetime creating? And of course, people answer me, yes. It's a resounding yes. So why plan? Again, to have a say, not only a say, a big say in what happens to yourself, your loved ones, and your assets when you're not around to make those decisions. I have to tell you, if you don't plan, a probate court judge may very well get to have a big say in what happens to your stuff. Sometimes people who you don't know or don't want to have a say in your affairs actually wind up becoming the people who are in charge. And as you know, even if you don't plan, the legislature has an estate plan for you. You either have your own rule book that you set up when you make an estate plan, or you've got the state's rule book if you do nothing. So you have to decide, Are you going to play by the state's rules, or do you want to play by your own rules? And like I said, assets can wind up with people that you don't expect, and by not planning, you also lose opportunities to save taxes and protect the assets that you have for the people that you want to have them. So those are all the reasons why you really want to sit down and plan. And a lot of people tell me, well, you know, you're right, the state has a mechanism in place to handle my estate, and I'm just going to rely on that. When people come back and tell me, well, I don't really need an estate plan, the state has a plan and I'm satisfied with what the state is going to do for me. Estate planning is not a question of a need versus a want. If you live in a certain house in your neighborhood, really look at it, is it a need or is it a want? The house that you live in, you probably selected it because you want your family living in a nice house. The truth is, you don't need to buy a house. You could be living in an apartment and have shelter for your family just the same. But you don't do that because you want your family to have a nice house. Same thing with respect to the car that you drive. Most families that I deal with, they have 2 cars. And truth be known, you don't need to have any cars. If you need it to get to work or get around, there's buses, there's public transportation. So in terms of a need versus a want with your transportation, you don't need to have a car, but you choose. You want to have a car because of the convenience that it provides you. And if you have children, a lot of my clients will move into certain neighborhoods because they want their kids going to certain schools because it's a good school district. Well, you don't really need your child to be in a certain school district to get an education, but you do it because that's what you want your family to have. So when you look at, you know, why do you live in the house that you live in? Why do you drive the car that you drive? And why do your kids go to the schools that they go to? It's not a question of a need, it's a question of that's what you want for your family. You want your family to live in the nicest house. You want your family to be driving the safest and nicest cars, and you want your kids to be going to the best schools. It's not a question of need, it's a question of want. Estate planning is the same thing. You don't really need to have an estate plan, but hopefully after you go through this seminar and listen to what you're going to learn here, you'll understand that it's something that you want. So, getting into it now, estate planning and the use of living trust. What's the problem? The problem that we face is transferring assets. So, there are really 6 different ways to transfer assets. As I said, you can have no plan at all. One of the famous plans that people come in and show me is they take their house and they own it in joint tenancy, which means that it passes to the survivor by operation of law. So they say, well, I have a plan, it's a joint tenancy plan. The other thing, people gift away their assets. And they say, well, I don't have to worry about planning, I've gifted away my assets. People come in and they talk to me and they say, well, I already have a will, why do I need to consider doing anything else? And you also can do a lot of things, believe it or not, we're going to learn about with a beneficiary designation. Beneficiary designation is on a life insurance policy or on a retirement account. And the last but not least is putting together a living trust estate plan. So let's go by one by one. Let's go by all of them and see what's good and what's bad and what's the pros and cons. No plan is where you just assume that your loved ones will get the assets that you have, that they'll be transferred to them in some course of action. And the result, of course, is the probate of what we call an intestate estate. Intestate simply means you passed away without leaving a will. So there are really no instructions. So the state has a mechanism in place that someone is appointed as administrator and the state goes through the court proceedings and will be effectively transferred to whoever the next of kin are according to what the state legislature has provided. So you've effectively adopted the state's estate plan. And of course I tell my clients, you all know that the state has your best interests in heart, right? And as I said, joint tenancy, you can add someone's name to the deed and it does avoid probate. If you're a husband and wife, you probably hold title to your house as husband and wife as joint tenants. And what that means is when one passes away, the survivor automatically by operation of law inherits the property. The person on title to the asset can sell it, transfer it, do whatever he wants with it. More importantly, that person's creditors can now attach that asset and the heir receives the property with your basis. So if you have your child on there as a third joint tenant with you and your husband, when you and your husband pass away, it's true, the property passes to the surviving joint tenant who would be your child. The problem is your child would be receiving that property with your tax basis, so there will be tax due when the child decides to sell that property. And what that means is, just to use some round numbers, if you bought your house for $250,000 and 30 years later the house is worth $500,000, and you use this mechanism by putting your child on the deed with you as a joint tenant. Well, your child then inherits that house at your cost basis, which was the $250,000. So by the time you pass away, if that $250,000 house had appreciated to $500,000, and then maybe if you're in Southern California to $1 million, your child is going to owe capital gains on that gain between the $250,000 and the $750,000. So what you've done is you've created a huge tax problem for your heir. Now you can gift your property, and the same thing with gifting property is, once you give it away, you no longer have it. So if you need it down the road, of course, once you've gifted it away, you can't get it back. So if you need to later sell it or use it, you no longer have it. Same thing with the tax basis. Your heir receives it with your tax basis, so when they sell it, they've got the same horrendous capital gains problem that the joint tenant heir would have. So while it'll accomplish the purpose, it's not the most tax efficient way to do it. People can also have a will, and it's great to have a will. At least you've left some instructions. Now the problem with a will is that it generally costs about 5 to 6% of the gross value of the estate to transfer it to the heirs. That's the costs that are incurred in probate. So if you've got a house that at the time you pass away is worth $500,000, you're going to have about $25,000 to $30,000 in probate fees just to get that house through probate. And there's an excess amount of time that it takes to probate an estate. Typically, it takes about 18 to 24 months to do it, according to the statute, if everything is done like clockwork. The problem with that is nothing in the courts ever goes like clockwork. Courts are backed up terribly. So that 18 to 24 month time period, it's not uncommon to maybe double those, 36 to 48 months before you get the thing through probate. And that means the family has to deal with that for 3 or 4 years after your death. Court cases are also public. So as a result of having a will, everything in your estate is subject to public scrutiny. And anyone can go down to the courthouse if they want to see nature and extent of your assets, who you left them to, under what terms and conditions. Just to give you an example, Bing Crosby, when he passed away, he had a trust plan. And to this day, no one ever really knows what the nature and extent of Bing Crosby's estate was. On the other hand, some of you may remember Natalie Wood passed away, the wife of Robert Wagner. They had a testamentary trust in their will. It was subject to probate, so her affairs were totally open to the public and public scrutiny. So if that's important to you, keeping your affairs private, a will doesn't accomplish that. Also, if you own out-of-state property, if you have a vacation home in Colorado or Nevada or Minnesota or wherever, that piece of real property in the other state has to go through what's called an ancillary probate. And as a result, it has to track the rules and regulations of not one, but actually 2 states. And by having out-of-state property in your living trust in the state where you reside, you bypass that procedure of having an ancillary probate. And last but not least is, like I said, the emotional effect. When a trust is in place, your successor trustee automatically steps into place as soon as you pass away. And those instructions are there to guide them. So it happens instantly with a trust. The probate process. Basically, to probate a will, you have to submit a petition to probate it, and the personal representative is usually the person you name as the executor, has to be appointed by the court. And in order to do that, you have to give notice to the creditors, to all of the heirs at law, all of the beneficiaries, and then a hearing is usually probably in about 6 to 8 weeks on that issue of whether that person should be appointed as the executor. And so for that period of time, whether it's 4 to 8 weeks, there's a period where the state is in limbo. Nothing can really happen until that executor has the court order appointing him or her as the executor. The other thing that happens through the probate process is there's a creditor claims period, usually about 120 days. And while that's happening, the executor gets to marshal the assets, has to pay whatever income taxes and estate taxes, if any, pay what's determined to be the lawful debts of the decedent, and then they get to make distributions to the beneficiaries. And it's that point that they file a final account with the court and tell the court what they've done, and the court gives its blessing and the estate is closed. So again, it's not uncommon for it to take 3 to 4 years to go through what seems like a simple process. Now, I talked about beneficiary designations. If you've got an IRA account or a 401k account, you have what's known as a beneficiary designation. And a beneficiary designation trumps your estate plan, believe it or not, because it's a contract right in that document. So if you have a 401k or an IRA, in there you can designate, obviously your spouse to be the primary beneficiary and your kids to be contingent beneficiaries and perhaps grandchildren to be what's known as tertiary or third level beneficiaries. All of those things happen without the probate process, without any supervision. It happens automatically by operation of law according to that document. It's a very effective way to transfer assets to your heirs quickly, and it's a very tax efficient way to do it. For instance, if you have an IRA in place when you pass away, and let's say it has a balance when you pass away of $100,000, I've seen some people name their trust the beneficiary of their IRA, and you can do that. The problem is, since a trust is a legal entity, it's not a person, when the IRA proceeds are paid to a trust, if it's not drafted properly, that automatically accelerates all of the taxes. So that $100,000 IRA would immediately become worth $66,000. You just accelerated $33,000 in tax. If you leave your son, your daughter, your wife, your spouse, your husband, the beneficiary, since they are a person, as an inherited IRA, they get the opportunity to stretch out their payments over their life expectancy. So if you're leaving your IRA to a child who's, say, 25, 30 years old when you pass away, that child can stretch out the payment over their lifetime. So think about the lifetime of a 30-year-old. What'll happen is that account will continue to grow on a tax-deferred basis while they draw out their required minimum distribution according to their life expectancy. It creates a tremendous opportunity to really let that account continue to grow. So, using a beneficiary designation with the proper advice from a lawyer or a good financial planner can really, from a tax standpoint, enhance the value of your estate, as well as having it done at literally no cost. So the last thing we're going to talk about is a revocable living trust. And people, they ask me, well, what is a trust? I'm nervous about transferring my assets to a trust. Do I still get to control them? A revocable trust, going through the definition, revocable, it means that you can change your mind at any time. It's totally amendable, totally revocable. Living, meaning it's established during your lifetime. You're effecting these transfers during your lifetime, so we don't need to go to a probate court judge to have them done later on. It's a trust. It's a paper legal entity, like a corporation. If you're in business and you have a corporation or you have an LLC, you establish that entity as a paper legal entity and filed it with the state. You sort of do the same thing with your trust, is you set up a paper legal entity that you're transferring assets to. And I tell people to envision your trust like a box. And when we give you your trust, you've got a pretty sturdy box. And then when the time comes to fund it, what we're doing is simply putting assets into the box. And we determine what assets belong in the box and what assets don't belong in the box, like your retirement accounts, because they have independent beneficiary designations. So the control, your trust can control assets not only during your lifetime, they can have rules and regulations on how your assets are going to be managed or controlled after you pass away. So if you have a child who has special needs, if you have a child that's not very good with money, your successor trustee can have specific instructions on how that money is to be dispersed, under what circumstances it gets to be dispersed. So it can provide not only control but also protection. Assets can be protected from beneficiaries, creditors, not your own. So for instance, if you leave your estate to your child and your child continues to manage their distributive share of your estate inside of your trust during their lifetime, while they control those assets, they don't own them. Your trust still owns them. So if they're being sued, or if they're being audited by the IRS, or if they're going through a divorce, those assets that remain in your trust, while they control them, they don't own them. So those assets, your assets, will go to your child, be available for your child, and not go to creditors or predators like the IRS or lawsuits. The other thing that your trust does is, God forbid that you become disabled due to Alzheimer's or early onset of dementia. Your trust document will have a provision in it that says if you're unable to manage your affairs, there are certain people who you know and have selected who will automatically step into place to manage your affairs and yourself personally if need be. It also can avoid some death taxes, although with the change in the estate planning laws, if you have an estate that is $5 million or less, you're really not going to have any estate taxes. But for couples that have estates of $11 million or more, this kind of a situation can at least minimize some of the estate taxes that they'd otherwise have to pay. And also, going back to my example about the transfer of assets in a joint tenancy or by gift, these assets transfer at a stepped-up basis. And what that means is, if that $250,000 house in my earlier example, which is now worth $1 million, is going to your heirs via a trust, your heirs inherit that $1 million house at its current fair market value, $1 million. So you've eliminated that $750,000 capital gains that they'd otherwise have to pay if you put them on the deed as a joint tenant or you simply gifted the house to them. So you can see there's a lot of advantages to having a living trust. It's a very efficient way to transfer assets, to control assets, and to do it in a very tax-efficient manner. What are the documents that are required? The documents that are required to have a proper estate plan are a revocable living trust, a pour-over will, a durable power of attorney for health care, durable power of attorney for finances, and you're going to want something called a living will, which is the declaration of what's going to happen to you in the event that you can't make decisions for yourself with regard to life support. And the last thing that you need to do is new deeds to fund the trust. And the reason I capitalize the word fund is, going back to my example, if you envision your trust like a box, funding the trust is simply putting assets into the box. And as I said, certain assets belong in the box and certain assets do not belong in the box. So what's the most common trust? The most common trust is the revocable living trust. It provides for the succession of management, gives you the opportunity to appoint a successor trustee. It's extremely flexible. As I said, if you can dream it and it isn't impractical, we can probably draft it. It provides for lifetime asset protection, divorce protection, public benefits, protection for children and grandchildren. You can eliminate the $5.3 million estate tax that would be due at each subsequent generation's death. And by having a living trust with a married couple, you effectively double that $5.3 million. That's where I was getting the $11 million figure from earlier. That number, that $5.3 million, is indexed for inflation. It goes up every year. What does a living trust not do? It doesn't provide asset protection for you as the creator of the trust, because if you can amend or modify your trust, if you have access to the assets, so do your creditors. It does provide protection against the costs of long-term care, nursing homes, Medicaid, Medi-Cal, if that's something that's to be considered. There's a special way to incorporate those provisions into your trust. As I said, it can save estate taxes for single individuals and affect your income taxes. The incapacity documents, those are the documents that come into play if you're, God forbid, diagnosed with Alzheimer's or early onset dementia. And these are the documents that you want to have in place to address those issues, so your heirs aren't forced to have to go to the court to have a conservator appointed for you. So the living trust can, to the extent that it's funded with proper assets, also work hand in hand with your durable power of attorney for finances, your healthcare proxy, and we also provide clients now with what's called an independent HIPAA authorization. HIPAA is the, if you recall, the Health Insurance Act that says, Health Insurance Privacy Act, that says that insurance companies, life insurance companies, employers, they can't disclose any information about you to people without violating your health insurance privacy rights unless there's a HIPAA authorization that they've been presented. So it's an important document to have for that reason. Your durable power of attorney. It can be either a present power concurrent with the principal, meaning that you appoint someone to act with you immediately, or it can be a springing power. We normally put into place what's called a springing power of attorney, which means it comes into effect in the event that you are disabled or unable to act. The principal, and you're the principal, can revoke or overrule that power at any time. The power of attorney ends with your death. So when you pass away, your power of attorney is no longer operative. Even with a revocable living trust, important assets that the living trust cannot own, plus powers not relating to assets at all. What that means is, for instance, your retirement accounts. That's why it's important that you have your beneficiary designation done properly, because your living trust is not going to be funded with assets from your retirement plan, because it's not a tax efficient way to do it. So your power of attorney would protect you during your lifetime to control those assets to a certain degree, but after you pass away, the power of attorney expires, so you want to make sure that that beneficiary designation is done properly, because that's not an asset that will be owned by the trust. It will not be in the box at your death. Power of attorney also gives us an opportunity to have a robust list of successor agents. So even if your first agent is not available, it can roll down to a second and a third. And normally that's what we advise clients, is to have at least 3 people on the power of attorney, in case usually husband and wife will have the spouse. And I tell people, well, what happens in the event of a common disaster? If you're in a car accident together or a plane crash together, your next in line is going to be with you. So you need to have a successor in place just for that reason. Most durable powers of attorney are cookie cutter, and key powers are often missing or inappropriately drafted. So it's really important. I see people download forms off the internet and just willy-nilly fill them out. It's not a good idea to do that, because you can really be creating problems when you think you're actually solving something and you're not. Your healthcare proxy, same thing. It's a springing power, meaning it comes into play only when you are not able to communicate your wishes about what's going to happen to you in terms of the healthcare that you're going to receive, or more importantly, not receive. It gives your agent the authority to deal with the attending physician. It gives your agent the authority to have access to your medical records. But it has to be a situation where you're not able to communicate what's known as an informed medical decision. It's not usually effective for day-to-day decision-making issues. It's something that comes into play, God forbid, if you're in an accident and you find yourself in the hospital. The hospital fill-in-the-blank forms are effective for probably 95% of the cases that I see. And a good healthcare proxy is probably effective in 99% of the cases that I've come across. So that's another important standalone document to have. The HIPAA authorization, as I said, the Health Insurance Portability and Accountability Act, which provides that doctors and hospitals and other medical professionals will be able to speak with your agent if you've signed off on a HIPAA authorization. So that's why you need a separate standalone HIPAA authorization. Your successor trustee, if they're named, or your successor agent in your healthcare proxy, may have to deal with Medicare or your health insurance company, and they won't talk to them unless they are satisfied that they've got a HIPAA authorization, because they don't want the liability. So it's important to have a separate standalone document that you can send to those people if they request it. So some particular problems. Single people. Single people have no partner who will presumptively be entitled to inherit as an heir as a matter of law. So having an estate plan is a wise thing to do. And I see plenty of young adults that are in their 30s, they're just buying a house, they're getting started, they have no kids. Without an estate plan, what happens to their stuff? Single people also have no marital exemption. So there may be a tax impact on how their estate is distributed if it's above those limits. And also, again, there's no legal document to recognize someone to manage their estate in the case of disability or distribute in the case of death. And in fact, even more so than that, when my clients' kids go away to college, I encourage them to have their kids sign a healthcare proxy and a financial power of attorney, because once your kids turn 18, presumptively you don't have the authority to make healthcare decisions for them, to make financial decisions for them. And when kids go away to college, a lot of times parents find themselves in a position that they need to make decisions for their children and can't. So with regard to single people, it even rolls down to kids that are turning 18 and going off to college, that it's important for them to have those two documents in order. Some other particular problems. I see so many blended families today. Blended families is probably the norm, where you've got people that have had two different marriages, there's two different families. How do we preserve the inheritance for a deceased spouse's children from a former marriage? There can be an unintended disinheritance if a surviving spouse remarries. Think about that problem. If you have a situation where both of you have been married before and one of you passes away, and your spouse is young enough that he or she remarries, well, what happens to the stuff that you have accumulated together if your spouse then predeceases their subsequent spouse? Does everything just go to that spouse? The trust can provide that a mechanism will be in place to protect at least what you've accumulated for your children in the event that something like that happens, that it actually goes to them. And you can have the use of the assets instructed to support a surviving spouse in a manner that you both determined is reasonable. Payment of burial costs. Believe it or not, I see so many people that come into the office and they have absolutely no plan in place as to how the disposition of their remains are going to be taken care of after they pass away. So many people will tell me, oh, I want to be cremated, or oh, I want to be buried, and I have to have the conversation. Okay, what mechanism do you have in place to make sure that that happens? What instructions do you have in place? So we actually have a form that we work with our clients that become part of the estate plan with regard to any pre-need arrangements that have been made. But believe it or not, I mean, people spend a lot of money preparing a funeral, preparing a burial, and final expenses can be quite expensive. Final expenses can be quite expensive. This is from 2014, where we've got statistics that show that the average burial is about $7,100. And that represented a 28% increase over the preceding 10 years. If you're in a cemetery that requires a vault, that will increase the cost even more, and many cemeteries actually require that. If your desire is to be cremated, you know, are ashes to be spread somewhere, or are they to go in a niche somewhere, you need those instructions in your estate plan to give your heirs some sort of idea of what you want done. Some people go to the expense of having final expense coverage. That is a question of you know, personal desire. 40% of the people that I talk to say they don't own any life insurance. So the question is, where is the money going to come from to accomplish the things that you want done at the end of your life? I also talk to clients about their IRAs and their retirement plans, because that becomes very important in terms of how an estate is passed. And I ask people, do you understand how your IRA or your 401k works from a tax perspective? And I go through this analysis, and if you have a couple that have been contributing to an IRA or 401k over a period of time, they're getting a tax deduction. And just to make the numbers work easy, I use this example. If they're in a 33 1/3% tax bracket and they're contributing $6,000 a year to an IRA, they're getting a tax deduction of about $2,000. And if they do that consistently over a 20-year period, they've effectively saved $40,000 over 20 years. And if that accumulation has done very well hypothetically, and they have $1 million in their IRA, when they go to retire and they start to take their money out, if they want to take out 7.5% to provide an income of about $75,000, based on that, they're going to owe about $25,000 in taxes, and they'll have net dollars available to them of about $50,000. And people say, okay, I got it. You have to ask yourself, for whose retirement did you just save? Because after 2 years, at $25,000 a year, you will have paid $50,000 in taxes. And if you recall, over 20 years, that $2,000 tax deduction saved you $40,000. So it doesn't take much of a math genius to figure out that the government is ahead by $10,000 just after year 2. So you have to ask yourself, boy, whose retirement that I just saved for. And if you've got a retirement that's going to last, say, 20 or 30 years, when you think about paying $25,000 a year over a 10, 20, 30-year period, year after year, add up the amount of money that you're paying in taxes to the government, and it's astronomical. So properly organizing your estate from a tax-efficient standpoint is very important. Here's another example of a couple who has Social Security and they're in retirement. So you take a husband and wife, if they've got about $3,900 in Social Security, and they're going to take a monthly IRA or 401k withdrawal of about $8,000. That gives them a little less than $12,000 to have in monthly income. When you look at the tax impact of that withdrawal, they're going to have to take out another $1,600 from their IRA or 401k to pay the taxes on the $8,000 withdrawal. They'll have to take out another $320 to pay the tax on this $1,600 withdrawal. And then, by having all of that provisional income, they're going to have to pay tax on their $3,900 Social Security income. That will be $680. So they're going to have to take out another $680 to pay the tax on the Social Security. And when they draw that $680 out, they're going to have to take out another $136 to pay the tax on that $680 withdrawal. Does that sound like madness? That's how our tax code works. So that couple will have to take out an additional $2,736 just to pay tax on the $8,000 withdrawal and their $3,900 combined Social Security benefit. And I ask my clients, did anyone ever talk to you or ask you, do you understand how these accounts work from a tax perspective? And more importantly, have you done anything to optimize how this will work with your estate plan? So what's the next steps from here? You have to ask yourself, do you have a plan for the liquidation of your assets in such a manner to support yourself during your retirement? And then, do you have a plan to pass it on to the next generation in an efficient manner? So, question is, should you set up a trust? And the bottom line is, if you own a home or if you have children, a trust is usually the preferred plan to manage and or pass your estate to your heirs with little or no delay or expense. I've been admitted to the California Bar since 1984, been admitted to the tax court since 1987, authorized to practice before the federal courts, Southern District 84, Central District since 87. I'm licensed to practice before the IRS. I've got an insurance license that helps me work with insurance companies and brokers. I've provided 2 mandatory continuing legal education courses for the state of California and Florida that I teach attorneys on some of these aspects. So, last thing I said, I was going to talk to you about fees, what lawyers generally charge to do these things. And fees will range anywhere from $750 up to $10,000, depending upon the nature and extent of the assets. But the usual range, honestly, is going to be between $1,500 and $5,000 for a typical estate. Our fees range between $3,900 for a single person up to about $4,400 for a married person. That is more or less for the type of trust where you've got at least $10 million of assets, because we're going to be coordinating your estate plan and your retirement plan. There's a lot of tax planning that will go into that. If you're looking to have basically a probate avoidance trust and to coordinate your retirement accounts, those fees go down. But I want you to understand what an upper limit may be if you have a somewhat complex estate. So I disclose worst case scenario. By looking at this video or attending one of our seminars, I offer a $350 discount. If you come into my office and say, I've watched your seminar on the internet, you mention that to me and we'll give you a $350 credit off our fees. We offer a free consultation. If you've come to one of our seminars, you know that. If you've watched this on the internet, you're entitled to a free consultation where you can come in, ask us personal questions. Because what I've given you here is just general information, and you can really see how this will benefit your family based on your specific situation. If you've already got a trust, an estate review is a good thing to do on an annual basis anyway. Things change. New children are born, people pass away, people move away. So even if you already have an estate plan, we can give you a second opinion as to whether or not any updates or amendments are appropriate or necessary for your situation based on the way your situation might have changed since you initially put your plan in place. So that basically concludes our presentation here. I want to leave you with this thought. The providing of legal services has become almost like a commodity. A lot of people come in and they say, well, you know, I can download a trust on the internet from this internet site or that internet site. And that's true, and they can do that for, you know, maybe $1,500 for a trust. And what I would caution you is it doesn't have specific provisions designed to really accommodate your specific situation. The other thing about those legal internet sites, what you're going to find out is they'll say, yeah, we'll provide you the trust for $1,500, but then if you want the pour over will, well, that's going to be another $500. If you want the durable power of attorney for finances, you know, that's another $500. If you want the durable power of attorney for health care, that's another $500. And basically, they wind up nickel and diming you to get you to put your credit card into their site, and you don't get any kind of specific legal advice or help. So that's what we're here to provide. That's why we're different. I encourage you to pick up the phone and give us a call. We're happy to answer questions. I hope this has been informing and enlightening, and I hope you've learned something from it. Thank you for listening.